We're now joined by legal analyst Mpumelelo Zikalala via Zoom. Very good evening to you, Mr. Zikalala. Thank you so much for joining us, and a warm welcome to Prime News on 3.
Good evening to you, and also good evening to your viewers.
Bombshell testimony, I must say. And could Madlala's testimony, be the missing piece of the puzzle in this very complicated case?
Well, it's going to depend how he's going to perform under cross-examination. Let's remember that whatever that he has stated, there are other two statements that he has made earlier. Probably that's the presumption that I would have. And also there's examination in chief. So if there are any inconsistencies which are going to appear, he's going to be quizzed on that during cross-examination with the sole intention of extracting the truth. At the end of the day, it has to be consistent on all three events or all three instances. By three instances, I mean the first docket, the second docket, and the witness, the evidence that is presenting now at court. So the more consistency there is, the more probative value that the court will place on his testimony, and the more believable his testimony will actually be.
And just considering all the elements of this very complicated case, so does the prosecution have a legal, a legal standing or a legal leg to stand on in terms of admitting the witness testimony? I mean, obviously the admissibility of such testimony will be thrust into the spotlight, isn't it?
Definitely, and you could see that earlier from today, there were various objections that were there. The danger of identifying someone who's in the witness box, they're basically sitting duck. At the end of the day, they have been branded of being accused, or they are even called the accused persons. So it's very easy for a witness, even if they're forgotten, to say, probably this is the person that was the intruder on the day, even though I don't remember. Despite the fact they had identity parades before and they weren't identified. But what I think the state is doing now is doing the job which was supposed to be done by the investigating officers. It was the IO which was meant to call upon these particular witnesses and say, we have reason to believe that there are new individuals or new accused that we have now been able to catch, and we can be able to link this particular crime. Can you come and attend to a proper identity parade that complies with the Criminal Procedure Act, so that at the end of the day, you are able to identify them in a pool or number of people which are not related to that particular crime? What that does, it brings weight to the evidence which you are going to bring later at court, and it says you were able to identify these individuals mixed with people who are not there in the first place. Mm-hmm. So the probative value or the accuracy of the weight of the evidence that you are bringing into the table is going to be high, other than identifying them now when they're sitting in the accused box, when they're the only individuals in which they are suspected to be the killers of Mr. Senzo Meyiwa.
At what point is public sentiment considered in a very complicated criminal case as this one? I mean, the public sentiment right now is that why are the other people who were in the same house where Senzo Meyiwa was killed not called into the witness dock? I mean, the name of Kelly Khumalo, Zandile Khumalo, Longa Twala has been bandied about, and the public are asking why are they not being called? In as much as speculation is rife that a neighbor might be called in to testify. At what point then is the prosecution or the people leading the case considering what the public might even, might be suggesting, if at all?
We must remember that we're still in the very early stages of this particular trial, and we need to allow the NPA to present a strategy, which I would believe that it has been carefully thought of. They are well aware of the reasonable doubt of being found guilty beyond reasonable doubt, burden of proof that they need to prove, and the amount of weight that must be attached, the amount of work which is attached to it. Now, when it comes to the presiding officer, which is the person who's going to evaluate the evidence, he's guided by the Constitution, by Criminal Procedure Act, by common law when it comes to criminal law, and other cases that have decided certain instances, maybe when it comes to when evidence must be admitted and when evidence must be rejected. We can't change his mind by looking at public sentiment at this particular stage, because it still has to extract whether the merits of the case are actually saying that the accused which are in the accused box are indeed guilty. After that, you can then maybe look at those when you are looking at the sentencing procedures. But for now, our opinions as members of the public should not influence the judge in any particular manner or the proceedings as they are happening in court. The prosecution is supposed to bring on their case in the manner in which it has been carefully thought of and prepared. The defense is supposed to defend their client's legal interests to the best of their abilities, and all that must be proved by both parties From the state side, you are guilty beyond reasonable doubt. There's no other explanation that can be provided except the one that you are presenting. From the defense, they are planting instances of doubt so that at the end of the day, their clients are regarded as innocent.
Right, right. And another interesting element of this case was, the controversial advocate Malesela Tefu, and we do understand that his legal career may be over. That is, if the Gauteng High Court in Pretoria rules in favor of an application by the Legal Practice Council to have him struck off the role of advocates or suspended pending further legal action. What should we read into this? Is it simply, a legal matter, or there could be a bigger issue at play here?
I think from where we are standing, we should treat it as a simple legal matter. The Legal Practice Act is very clear as to how legal practitioners are supposed to conduct themselves. If there are instances in which one has misbehaved, there are various mediation processes that are there. There are various opportunities in order to answer. So the court is the last resort or the last forum in which a legal practitioner can be dragged to in order to answer. And it's always easy at the end of the day, or a possibility of saying, yes, I've done something wrong. I'm prepared to get the punishment in which I'm willing to receive, and it ends there. And also look at the timing. When did these particular legal woes actually start? And when did this particular trial actually start? So when did he actively participate in this trial? So for me, at this stage, I don't see any interference or any relations between the two. Maybe at a later stage, with the emergence of new evidence, one may come to this conclusion. But for now, it is purely a simple legal practitioner complying with the Legal Practice Act and the conduct which is attached to a way a legal practitioner ought to behave themselves.
All right, Mr. Zikalala, great chatting to you. Thank you so much for sharing your analysis with us.